discussion. And I'm happy to moderate this panel today on the rights of non-humans in the Anthropocene. So we'll hear from Josh Gellers, who's an associate professor in the Department of Political Science and Public Administration at the University of North Florida, a research fellow of the Earth System Governance Project and core team member of the Global Network for Human Rights and the Environment. He was also a US Fulbright scholar to Sri Lanka. Josh's research focuses on environmental politics, human rights, and technology. His work has appeared in numerous peer-reviewed journals and cited in 7 UN reports. Josh runs the Enviro Rights Map, a free Google Maps-based website that catalogs constitutional environmental rights throughout the world. And he's the author of The Global Emergence of Constitutional Environmental Rights and Rights for Robots, Artificial Intelligence, Animal and Environmental Law. And then we'll hear from Matilda Arvidsson, who has studied law in Lund, Jerusalem, and Khartoum. She completed her LLD in international law at the Faculty of Law, Lund University, from where she also holds an LLM in jurisprudence and a BA in political science. Her research interests are interdisciplinary and include law and theory, migration law, international and public law, humanitarian law, posthumanism and technology, artificial intelligence, as well as the embodiment of law in its various forms and in interspecies relations. She has been invited to talk about her research in various institutions around the world, most recently at the University of Technology, Sydney, Australia, Western Sydney University, Australia, Kent Law School, Canterbury, UK, La Trobe Law School, Melbourne, Australia, Melbourne Law School, Australia, Uppsala University, and Copenhagen University. In 2019, she received the Bernadotte Program stipend from the Royal Swedish Academy of Letters, History, and Antiquities. So we welcome your questions as well. You can type your questions in the chat and I'll moderate and ask our wonderful panelists the questions after they are finished. So with that, I'll leave to you, Josh.
Well, thank you very much for that great introduction, and for Matilda for also serving as an additional member of this panel. I'm really excited to have the opportunity to talk about what I hope is sort of a conversation starter to discuss several disparate or seemingly disparate movements related to the rights of non-humans, which I'm hoping will be connected in a meaningful way, and I'm doing some work along those lines right now. So I'm going to share my screen so that I can pull up the presentation. And I think everything is good to go now. So again, thank you very much for having me here at this GNHRE-UNEP Summer Winter School for a talk on the rights for non-humans in the Anthropocene. So I think it helps to think about how I came to this, and hopefully some people will have had similar experiences along the way that drew them to this subject. So on the one hand, I've spent most of my career studying environmental rights, and more specifically environmental human rights. But because of some advances in the rights of nature, I saw that a lot of people who are working on the area of environmental rights from a human perspective have since migrated or paid more attention to the development of rights of nature. And so as an example of this, we have seen in several jurisdictions throughout the world, but most notably places like Ecuador, the rights of nature in the form of ecosystems or rivers or glaciers and so on. And I think what's really key here is that the assumption of human rights and some of its underlying fundamental aspects like dignity really relate to humans exclusively, or at least ostensibly they do. And but we've seen a movement toward acknowledging the rights of non-human natural entities, which no one would possibly mistake for an actual human. So they don't seem to meet some of the criteria that we normally associate with the application of human rights, and yet we see the extension of rights to them, which I suggest is something of an evolution that is pushing the boundaries of some of these erstwhile set in stone concepts. So I think it might have been on Twitter years ago when I saw that the robot depicted here, whose name is Sophia and was created by Hanson Robotics, was granted citizenship by the Kingdom of Saudi Arabia in 2017. And what's notable about this, aside from the fact that some people considered it to be just sort of a gimmick, is the fact that this robot, clearly another non-human entity, has a kind of right that people in Saudi Arabia don't enjoy. So what I saw emerging from these kinds of events were, on the one hand, an increasing acknowledgement of the rights of clearly non-human entities, and then on the other hand, an increase in the rise of humanoid robots. And it led me to think about this question about who we grant rights to, what kinds of entities are potentially eligible, and what is the basis for making these kinds of decisions. So this led me to the question which motivates the talk for today, which is, who belongs to communities of justice in the Anthropocene? And so this is a little image which is oftentimes used to depict a kind of ecocentric environmental ethic, where no one type of being is higher on the hierarchy morally or legally than any others, but they all exist in the same kind of plane of radical equality, which is a theme which I think is helpful for thinking about how we welcome non-human entities into our moral and legal universes in general. But in order to get to the point where we can make these kinds of distinctions and answer the question, in the course of my writing, I felt that we needed to perform three moves, so to speak. The first is to clarify conceptual relationships. And that is because in my reading, I saw that a number of scholars, usually legal scholars and philosophers, often had a tendency to talk past one another. Sometimes they would be using the same language like personhood, but other times they would be less inclined to share which kind of personhood they're talking about. Sometimes it's moral personhood, sometimes it's legal personhood. The most confusing phrase I think I came across was the right to legal personhood. So we have philosophers, legal scholars, and other kinds of folks who are talking about these issues, but oftentimes not in the same language, or they mean different things. And so I felt like it was really important to understand how these concepts relate to one another. The second was, once we have kind of put all of these concepts together, to think about the next step, which is to devise a framework through which we could think about the kinds of entities that might be eligible for inclusion in moral or legal universes. And this would require thinking a little bit more critically, more holistically, and in a more complex fashion about how those concepts relate to one another, conceptually or perhaps even causally. And then finally, it wasn't until much later in the process of working on this issue that I realized that when making these kinds of distinctions about the entities that are part of our moral and legal universes, that there would need to be room for an ethical orientation, which provides us with additional understandings about how we should make these kinds of decisions. And that if our overarching worldview wasn't informed by such an ethic, it was going to be very difficult to think about what candidates are out there and which ones should be elevated to enjoy more moral or legal status than, say, ordinary objects. So an ethic was really a late entrant into this conversation, but a very necessary one. The next thing I'm going to talk about are what I call analytical keys. And these are tools that I found very useful when trying to answer the question or go throughout the three moves that I just previously mentioned in the past slide. The first is from philosophy, and it's called the argument for marginal cases. And this is where we look at cases in which a human usually is in some way at a deficit or lacks a particular property, which is often associated with moral or legal status, and yet that individual is still thought of as having personhood or rights. So the question is, if someone has demonstrated an absence or deficit in those areas, what else do they have in common with other entities that allows them to be eligible for, legal personhood, legal and moral rights, and so on. The second analytical key is also from philosophy, and that is this sort of subfield of new materialism, which really helps to understand the role that agency plays in these conversations about personhood and rights. And so the insight that new materialism grants us is that everything has some degree of agentic capacity all the way down to the molecular level. So if we're only thinking about certain kinds of humans as being worthy of moral or legal rights by virtue of the moral agency that they have, once you realize that agency drills down to even a molecular or atomic level, it becomes less tenable to argue that moral agency is the main criteria by which we determine things like moral rights. And then finally, a really crucial addition to this conversation, which I hadn't thus far seen from the robotic ethics, and maybe to a lesser extent from animal ethics and animal rights, is an acknowledgement of the importance of the Anthropocene and the role that it plays in shedding a light on some of the concepts that we have taken for granted throughout the past several decades. Probably the most important of which is this idea that if humans are impacting nature to the extent that they are driving climatic phenomena, and in some of the work that I've done several years ago, that there are no meaningful differences between what we think of as the outdoors and the inside world, the built environment versus the natural environment, this erosion of these dichotomous concepts has to signal that maybe some of the other concepts we've been thinking about for a long time, like those between man and nature or nature and culture, are also much more permeable than we previously thought. So the Anthropocene is really the kind of blanket or the broader context in which I think we can have this sort of conversation where it might not have been possible before. So in the course of my reading, I realized that a lot of the ways in which we talk about different entities are completely different with respect to the kinds of rights that they might be afforded. And so I'm referring to these as incommensurable rights arguments. And so I've outlaid here several different categories of entities and the oftentimes major arguments used in favor of extending them moral or legal rights. And so humans, by virtue of their humanness, have dignity, and dignity is the thing that is central to the extension of rights and their protection under the law. Of course, though, that is something that not every other non-human entity is apparently shares. In fact, there's I'm jumping ahead here a little bit, but there's a chapter from an edited volume that specifically talks about the relationship between robots and dignity, and finds that if dignity is the basis for rights, robots definitely do not have dignity, at least not at present. So the point is that dignity is not a very portable sort of criteria for thinking about what might have rights and what doesn't. The next is animal rights. And there's been a resurgence in animal rights scholarship, some of which has been recently published in the Journal of Human Rights and the Environment, which I found very interesting. But a lot of the scholarship outside of that, and especially the earlier scholarship on animal rights, tended to be quite limited in its purview. So typically, animal rights scholarship focuses on certain properties that animals either do or do not possess, or from a Kantian perspective, how animals relate to humans in terms of human emotions and human interests, and those being the basis for extending rights. And so some of the major properties that we see associated with animal rights are sentience or intelligence, and it becomes kind of a measuring exercise whereby if we can determine that a certain animal X has a certain degree of sentience Y, then that animal will qualify for rights or some kind of moral or legal consideration. But of course, the problem with that is that even philosophers can't really agree upon what they mean by sentience, what they mean by intelligence, what they mean by rationality, or any other properties for that nature, or for that reason. And so, it really turns into a question of who you're talking about and which of the properties they're referring to. But philosophers and legal scholars have by and large not been able to agree on one or more properties that animals possess, and animal rights tends to be very under-inclusive. And that's why I like to use the image of a crab here, because we look at certain animals as, almost inherently possessing some kind of moral worth by virtue of their closeness to humans, and others clearly not having the same eligibility because they seem so divorced from humans. And so we tend to approach this, as well as obviously human rights, from a very anthropocentric lens. Then shift over for a moment to nature. The arguments used in support of the rights of nature are completely different from those used to adjudicate the rights of humans or animals. And they are not exhaustively, but kinship that humans have with nature, or nature in a very, very holistic sense, the biocultural rights of indigenous groups, and then maybe more skeptically, the societal needs that are promoted. And so there's a reason to want to think about bringing nature into the moral or legal folds where there's a compelling societal reason to do so. So this is more of an ecocentric, anthropic perspective because it tends to orient itself to, as Arne Naess would say, the total relational field image, but also with the recognition that humans are the ones making this distinction, which is why I've appended the word anthropic to the end. And then the work that I did in my book was trying to look at these three areas and see how they relate to a clearly non-human entity that nevertheless has its own sorts of interesting relationships and questions around, and that is artificial intelligence or robots, which borrows from humans, animals, and even nature to try and cobble together a theory of rights that would apply to non-human artefactual entities. Just to speak for a moment about dignity, because that was the one that I highlighted in the previous slide. There are a lot of different theories about how we arrive at dignity, and just a few of them are listed here from Kramer in 2020. There is this idea that dignity is something that is biologically determined, or God-given, or it's associated with human rights, or it's one of several properties that, in particular humans possess. Or the more skeptical view is that dignity is really an empty concept, devoid of meaning, that doesn't have a kind of intellectual coherence. And so it's really a placeholder for other things like some of the rationales provided above. And so the point is here is just to highlight the fact that dignity is not a monolithic concept, and therefore it's not very easy to simply apply it to some of these other non-humans in order to determine whether they are eligible for rights. And so I skipped ahead a little bit on this, but just to kind of recap, generally speaking, in moral philosophy, the rights of non-human entities is looked at through these two opposing camps, or not always opposing, but oftentimes opposing. One are properties. And the people who espouse a properties-based approach to moral worth look at a number of different traits, oftentimes human traits, that they say either exist or do not in another entity. And the extent to which an entity possesses one of these properties is the formula by which we should determine its moral value. And so these properties include things like I mentioned previously, consciousness, intelligence, rationality, and so on. And again, the question then becomes, which of these properties is the most important one for the purposes of determining moral worth? But scholars, by and large, have not been able to agree on this. And then there's the empirical problem of trying to determine its presence in another entity. So we know that there are, for example, higher primates that are capable of engaging in sign language. But is that tantamount to the kind of intelligence that we would need to determine that they have human rights, or rights because of their intelligence? Because if intelligence is the primary criteria, then what do we think about forms of artificial intelligence that already at present vastly exceed the ability of higher primates or even some humans to engage in otherwise intelligent actions? It's almost somewhat meta-ethical in a way, or meta-philosophical, that I should be delivering this talk while artificial intelligence, but more specifically, natural language processing, is recording what I say in real time below in a way that other entities listed here would be completely incapable of. So it gets us to think more critically about whether it's even possible to determine moral or legal value on the basis of one or more properties. The other one, which is a little bit more complex and has been talked about by scholars such as David Gunkel and Mark Koeckelberg, and then also in the animal context, I would argue by people like Brian Favre, are this notion of relations. And it takes this, this idea promoted by David Hume, that typically what we do is we have how we, what an entity is, and that determines how we ought to treat it. But people like Gunkel and Koeckelberg have talked about reversing this Humean thesis to think about how we ought to treat things in general, and then we are confronted with something and what it is revealed to us. And so they argue that our relations with anything, for that matter, be it human or non-human, it might be a better way to determine the kind of moral or legal value that we ascribe to it, because it has to do with, the interactions that we have, the relations, the social context in which they are occurring, the broader, as I'll mention later, ecological context in which it's occurring, and that unlike trying to have a horse race between different properties, relations, although in a more complex way, might be a more intellectually satisfying way of trying to determine the eligibility of certain non-humans for rights. And there have been, certain approaches throughout time that have looked at this as a either or proposition, or some people have argued that it's both. And so I try to look at that as well, because I think that there is a degree of endogeneity going on here in terms of whether one drives the other. And I think it's inescapable that we'll have to talk about properties when we discuss our relations with other entities. So what I've done, and I'm not going to belabor this point and talk about this ad nauseum, but is try to make sense of how literature from legal scholarship, from philosophy, from computer science, and so on, talks about these concepts of personhood and rights. And I've tried to summarize that in the form of a conceptual map. And what you can see on the far left side is I've generally separated them into two different categories. On the one hand, there are these properties, which for the sake of continuity with literature, I call ontological properties. And then the lower category, which I refer to as relational mechanisms. And so what's important here is that certain kinds of properties relate to certain kinds of personhood, and then status, and then ultimately rights, be they moral or legal, on the far right side. These include things I mentioned before, like consciousness, intentionality, sentience, intelligence, but also responsibility, autonomy, capacity to be a legal subject, the capacity to possess rights. Dignity is a property. The relational mechanisms are, I would argue, much more universal in terms of their cultural appeal, but also require that we do not simply promote Western ideas about moral and legal value above others. And we draw a lot of more inspiration from Eastern and indigenous ways of thinking, which is how I derived some of the relational mechanisms discussed at the very bottom, like animism, kinship, and self-realization, for example. But there's also other universal tendencies like anthropomorphism, which we see in lots of different contexts, but are very related to what I say is relational personhood. And relational personhood ultimately, I argue, undergirds the other cognate forms of personhood like legal, moral, or psychological personhood. So there's really no way to fully divorce some of these relational mechanisms from the properties and the attendant personhoods that they relate to. So what I've done is try to take some of those lessons and render them more complex, but also hopefully in a way in which it's intelligible to a wider audience, how we can reach at some conclusions regarding the entities that might be welcome within moral or legal circles. And so in order to get there, there are three things which I discuss as being really, really crucial to this project. The first is to resolve logical inconsistencies, because one of the major problems I noted in moral philosophy and in legal scholarship, especially on animal rights, are all these inconsistencies between different kinds of entities and the sort of criteria that we apply to their candidacy for rights. The argument for marginal cases is a terrific example and a way to shine a light on some of these issues. Because, for example, if there's a human who, for reasons related to congenital birth defects, is not as intelligent as, say, a fully grown adult, or never will be, But we have artificial intelligence, which is clearly much more advanced in terms of its intelligence than that human, then that suggests that it cannot be intelligence that serves as the primary criteria by which we determine moral or legal status. And so there's all kinds of things like this. Animal rights is rife with these sorts of issues where certain animals, by virtue of their properties that they possess, might be worthy of moral or legal value, but then others are not. And then, we don't have really good reasons why non-vertebrates are not worthy of moral value, even if they're more intelligent or perhaps more conscious, because they lack a central nervous system or things like that. So there's just a lot of logical inconsistencies which I sought to resolve. The second, again, speaking to the Anthropocene, is that we have to reject these simplistic binaries in favor of more complex relations. So because of the insight that we can no longer view humans as existing outside of nature, but rather they are always within and acting upon nature, it doesn't make sense to speak of humans and nature as separate from each other, but rather their fortunes and their futures are bound up intrinsically. So I admittedly reject these kinds of binaries between man, nature, nature and culture in favor of a more complex understanding of different relations. And then finally, as I sort of hinted at a couple slides ago, one of the major issues is, and this is perhaps undergirds some of what David Gunkel likes to call secular fundamentalism, is an insistence that there is only one way to know about the world, a kind of dogmatic epistemology in which only Western ways of knowing about the world are right. And that pertains to how we determine what has rights and so on. And so what I try to advocate for here is to respect and elevate indigenous and non-Western ways of knowing, because they are at least as valid as those that have been promoted for decades, if not centuries, as the primary ways that we think about personhood and rights. And it's time that they be understood as occupying a place of importance in that conversation. And so what I've tried to do is summarize all of this in the form of what I call a multispectral framework for personhood. And so it's multispectral in the sense that I have these little pluses and minuses, which mean that for any given form of personhood, an entity, an actant, an assemblage using kind of Latourian language, the holistic, grouping of entities, they possess more or less of something. And there is no clear benchmark beyond which we can say that this animal deserves rights, or this robot deserves rights, or this glacier deserves rights. It's always a kind of sliding scale that has to be necessarily context dependent. So what's universal about it is the assemblage of these different criteria or ways of thinking about different forms of personhood, but what is particular are the contexts. And so I had this nested model in which, so for example, the mentality more or less feeds into psychological personhood. So that includes things like intelligence, but that is understood within a social relational context, which could be a family, it could be a village, it could be a city. And then the broader social ecological context, the planet in particular. And so again, like with the previous conceptual map, each of these forms of personhood necessarily extends from relational personhood, which itself is based on both context and the physicality of an entity. And the reason why I include that is because the manner of relations between humans and non-humans, or non-humans and each other, is in part a function of the physical appearance of those entities. There's an emerging area of research, for example, on robotic fish. And they look at how real fish or biotic fish interact with robotic fish, and that is in part influenced by how the robotic fish appear to the natural fish. And the same rule applies for humans, albeit at different ages and different cultural contexts, and the way in which they interact with non-human entities, everything from technological beings to religious idols to natural resources and so on. And so these different forms of personhood are all intrinsically related to relational personhood, and they are to be understood within a social, relational, and social ecological context. And then, as I mentioned at the end, what I had to do was think about an ethical approach which would allow us to make decisions about how we decide upon which entities could be considered for inclusion in our moral and legal universes. And so I have three different areas here, which I'll briefly highlight, that sort of explain what a critical environmental ethic would look like. The first is an ontological dimension. And this is one that moves away from individualism and toward radical holism, in which, as the bottom bullet point says, anything that is a vulnerable entity in an open ecology is potentially a subject that could be part of this conversation. And then also, like I sort of hinted at in an earlier slide, it moves from a more exclusively anthropocentric view to an ecocentric anthropic viewpoint, where the perspective that is taken is a holistic one that includes nature as an entirety rather, but recognizing that humans are the ones that, just by virtue of the systems we've set up, will be making these kinds of distinctions. Although we have to think about, and I think this is really one of the key points, that any decisions that humans make have to be made with the idea in mind that a non-human could be awarded a certain status above and beyond which that is granted to humans. So practically speaking, this means that if the rights of nature were in court, and it was the rights of nature versus, the economic imperative of development, that humans would have to be able to lose in a court of law in order to actually fully transition to a more ecocentric anthropic perspective. The second component to a critical environmental ethic is an epistemological one. And this is an Anthropocene-inspired radical equality, where animals would have just as much a right to exist as trees or humans. And it would also welcome a range of rights foundations, not simply looking at the will or interest theories of rights, but a pluriverse of rights foundations that are relevant for other kinds of cultural contexts, not just looking for or looking to Western societies for inspiration. And then finally, there's the normative element to this, which is that any kind of distinctions, decisions, policies, and so on would have to be made with the following considerations in mind. They would have to be ecologically sensitive, so things that would pose a threat to the environment in some way could not be considered to be ethical under this particular perspective. They need to also promote justice and equality. And here I'm thinking of justice in very broad terms, like the group of scholars who talk about multi-species justice, or the other group of scholars who talk about planetary justice. So I consider these phrases to be, or these concepts to be, very broad in their orientation, but more importantly, to include non-humans, because you don't get to employ a critical environmental ethic at all successfully if it will just wind up replicating some of the human-centric biases that our previous ethical approaches have already been presenting for a long time. So I'm going to stop my presentation there. I hope you found this provocative, controversial, and hopefully interesting. I look forward to your comments and questions. If you're interested in talking offline, I have my contact information below. And if you'd like to check out my book, it's totally free via open access. And I put a QR code here at the top so that you can check it out on your own time. So thank you very much for your attention. And I'm very much looking forward to Matilda's comments and questions as well.
So thank you so much, Josh, for this fabulous and rich presentation. I think it was very clear, and to all of us, I think it has raised important questions. So I prepared two questions that are also comments, and I'd like to pose them to you before we open the floor for further questions and comments from the audience. And they are, in a sense, questions that you have already given us the answers to them, but maybe you can just rephrase them as I pose them to you somewhat provocatively. So first, well, as many of us in this room, I'm a lawyer, and as lawyers, we are often eager to bring law and justice to all. But what problem is law or legal rights for robots an answer to? So as lawyers, we often come sort of with a legal answer when there is a legal problem. So what is the problem? Apart from law being internally incoherent or inconsistent when it comes to who gets or what gets to count in terms of legal rights. So what is the problem? And once we sort of define the problem, is this a problem that can be solved by other means than law? So in saying rights, we do sort of invoke that it could be legal rights, it could be moral rights, it could be law proper, but it could also be ethics. You have already given us sort of an answer to that, but it would be great to hear you a bit more about that. Moreover, if law actually helped creating the problem that we are approaching here, is law the best answer to a problem that law has been part of co-creating? So this sort of, the head question, what is the problem and how is law entangled in producing that problem, leads me to my second question. So this is a question informed by law's colonial, racist, sexist, ableist and speciesist past and present. Are there certain things, objects, entanglements, whatever we want to call them, who are banned from legal protection or rights? If so, why and where do we draw the line? Should, for example, to give you a concrete example, I'm sure that the audience has loads of examples that I want to discuss as well. Should viruses have rights? If so, under what conditions? Or should we say that robots at least should have rights, whereas other things or objects or entanglements, such as viruses, shouldn't have rights? So those are the two sort of questions that I wanted to kickstart the conversation with.
Well, those are really important questions, which I think actually, upon hearing you say them, I probably could, and I hope I will, do a more serviceable job of trying to explain this issue, because one of the criticisms of rights for technological entities in particular has been, is this an answer in search of a problem? Are we putting the cart before the horse, so to speak? And we don't currently have what we think of as the sort of maximally human archetypal robot that maybe it would be valid to be thinking about this. And science fiction is rife with these sorts of examples, whether we're talking about a television show like Westworld or Star Trek, and then obviously there's literature that has also touched upon these kinds of themes as well. But we don't really have, I think, what people envision as being the sort of exemplar that would warrant this kind of a discussion. So some people have argued that this is a conversation that doesn't need to happen, and there are more pressing issues which need to be addressed more along the lines of ending human suffering and things like that. So I think that's probably one of the more important questions to address. So I'm going to start with that, the what is the problem question, and is sort of rights for non-human entities an appropriate answer to it. I think one way to think about this is, and this gets back to the properties versus relations dynamic that has occurred throughout the past few decades in moral philosophy. The problem is that once robots start entering, or any really non-human entities start entering our social worlds, there are conflicts that emerge. And the question then becomes, what is the legal way to address those conflicts? And then what is the ethical way? How should we be thinking about that? And to give you one example, which I argued just on Twitter a while back, is sort of the inspiration for this kind of a debate, is in my home state of Florida, where I am now, the state legislature banned childlike sex dolls, which would, the way that the legislation is written, would most likely include robotic childlike sex dolls as well. There are probably, if there aren't already on the market, such, toys, equipment, robots, whatever, in development. And so it's really interesting to see a legislature argue that from a regulatory standpoint, this is something that should not exist. And that's another one of the criticisms that the sort of anti-robot rights folks often say, is that the answer to this is to not make things that look human, to not make things that people trust, and so on. But the problem is that not only are non-human entities already part of our social world, and increasingly so, if you look at areas like education, healthcare, retirement facilities, they're being implemented because of some of the benefits that they have. Japan is obviously kind of leading the way in a lot of this. But if, for example, there were, and I use this in a slightly different way, but to talk about the Japanese example of how anima, how objects are imbued with spirits based on the context. And so if a robot were just in a factory sitting on a shelf, I'm not sure we would have a conversation about rights. The rights of nature is, I think, a lot easier for people to conceive of, if only because they're more familiar with nature. And they probably have some understanding of rights. It's the intersection of those two that becomes a little bit more challenging, because they don't see them as human. And when we talk about rights, we often are speaking of human rights. So the reason why I started this off by talking about sort of humanoid social robots is because they definitely look a lot more human than an iceberg does. And yet we have had already law explained to us in different jurisdictions that a glacier, an ecosystem, an animal has rights. So I think the problem emerged where we have, not unlike humans encroaching upon the habitat of a wild animal, we have technology encroaching on our social world. And to give you one concrete example of this, and I forget exactly where this happened, but there was recently a kind of robot that operates on sidewalks that was given the right of way as a pedestrian in order to resolve a real world conflict. And so I think the problem is, and autonomous vehicles are probably maybe even a better example, not that they have their own rights, so to speak, but that a lot of the ethical issues that emerge as a result of their deployment in especially urban centers, I think brings these issues to the foreground. Once we start inviting these kinds of things into the world, new conflicts that we might not have thought about previously happen. And so I tried to raise in my book a couple of examples of these, one of which would be someone striking a maximally human-like social sexual robot on public transportation, but all of the onlookers don't know that it's a robot. So that's at least an ethical question from the standpoint of a Good Samaritan law. Are you required to intervene in what looks like a violent act where you don't know whether the victim is human or not? Would we apply the same thing to animals? Could you be charged with a violation of a Good Samaritan law if you fail to stop cruelty to animals? So there are those kinds of issues that are already happening. And I think the philosopher, I think it was John Danaher, who said it's basically going to be impossible to prevent roboticists from developing robots that look and behave just like humans. So I think it's a bit of a unrealistic conceit to think that we're not moving in that direction, which isn't to say that we're there right now, but I think the more that we think about these issues now, the better prepared we will be for them in the future. The second part, what other ways are there instead of rights? People like Cass Sunstein have argued in the context of animal rights that all we need are animal welfare laws. We don't need animal rights. Animal rights activists would probably not greet that argument very kindly, because rights gives protection a kind of gravitas that simple welfare regulations do not. And we wind up often in these really weird situations where it's legal for a farmer to kill a cow, but not to hit their dog, right? So there's a lot of regulatory gaps that I'm not sure the ethics are pretty forward thinking, but the laws really haven't gotten up to them. So rights could be much more comprehensive in terms of the types of entities and the conditions under which they would apply. And then I love to talk about this because it's the only research I've seen on this topic, but Gabriel Lima and others conducted a survey to ask people what kinds of rights do they think robots could ever even have. And the number one suggestion that garnered popular support was the right to be free from cruelty. So even people see an analog with animals, and I would argue that that's probably because of our own human anthropocentric sensitivities toward how we interact with non-humans. But maybe that's where it starts. Maybe that's because we already think of humans and we already are familiar to an extent with animal rights. So I think that regulations alone, ethics alone, probably won't get us to the kind of all-encompassing situation where we are likely to see avoidance of certain kinds of behavior, deterrence, because of the rights that they would potentially run up against. And then are there things that we might not, or that are banned from legal protection? If so, why? Where do we draw the line? I don't have a great answer to this question. It's one that I think needs to be debated. Viruses are a great sort of hard case. Another hard case, which I've talked about with another person who's written on the subject, he wrote a book called Robotic Persons. His name is Joshua K. Smith. We've sort of floated the idea of, if relations are going to be the primary way by which we adjudge the entry of certain non-humans into our moral or legal circles, well, what about a fetus? If, for example, someone is interacting with, as if it's a child already, even though it isn't out of the womb yet, would it be entitled to certain kinds of rights because of the interactions it has with it? So that's another kind of hard case for the application of my multispectral framework. I think maybe where I can get some clarity on this is going actually back to the properties, because we know that there are certain things that touch upon the human tendency to engage in anthro or zoomorphism. And we know that it's things like having two eyes, having a mouth, being able to speak. When I was doing my field research in Japan, I went to a company that produces a robot called the Lovat, and they deliberately designed the robot with two gigantic eyes that you could customize, because they said that the eyes were a window to the soul, and it was really important for the elderly people who were going to be interacting with it to get some kind of visual stimulation by virtue of the way that the robot looks, because it's not necessary for a robot to have eyes in order for it to function. It's only necessary for smoothing human-robot interactions or robot-animal interactions. So the properties can't really be fully extricated from this. The way in which something looks is going to affect how we react to it. So one suggestion that I've seen, which I thought was really smart, was that a robot has to have some way of signaling to other things around it that it is a robot and not a human. That might, whether it's a light, for example, in the United States, we had a regulation passed where guns had to have an orange tip in order for people to determine that it's not a real gun, it's a toy gun. And that was supposed to, avoid obviously some harmful circumstances. So maybe something along those lines where a robot has to telegraph to entities around it that it is in fact not a human, and that will help us to understand what kinds of regulations or rights might apply. A virus, no one would ever probably think of it in sort of anthropomorphic or zoomorphic terms, even if they might interact with it by succumbing to it or, railing against it when they're sick from it. It's not the same kind of entity in terms of its social relational context. So I think it's a great hard case. I think there's probably more research to be done that teases out what are the conditions under which we do not extend rights to something. I think that would be a really worthwhile endeavor to complement this kind of a conversation.
Thank you so much, Josh. I think that was very clarifying and also enjoyable to hear you expand on that. So I have to ask our moderator, do I have some more time or should we open up for the audience?
I think you can pose another question if you want, and then we can open to we have a lot of questions actually from the audience, but
Oh, fantastic. Okay, so then I'll just take the opportunity to flip the question altogether or flip the perspective. So for some of you who know my scholarship, I come from international humanitarian law, and one of my first encounters with AI or advanced technologies in terms of thinking about it as a lawyer was in meeting with drones, and in particular swarming AI drones. And in the literature that I saw coming out on this question or this particular phenomena, the question was always from lawyers: how can we recognize this new phenomena, this new technology? How can we organize it as fitted into a already existing pattern of law? Natural. That's how we approach problems, phenomena as lawyers. However, when I started to look at what do these swarming drones look and act like, I immediately realized that they act very much like soldiers, meaning that the soldiers were actually more machine-like or equally machine-like as were the technological entities that no one would argue would be humans. Even so, the two different kind of entities, the soldiers and the swarming drones, they were treated in very different ways. Now, the question. So, what happens in terms of thinking about rights for robots and other entities that are non-human? What happens to the question of rights when we no longer, in that very distinct way, can make a distinction between what is definitely human and what is definitely robotic? When we have tech-enhanced humans, or when we have bio-tech human entities that are clearly of mixed origin, should we think of it as a mixed system for a combined entity? Or should we say that whenever there is a human biological entity, then that is human in character, and it has to have the rights that apply to humans. So I'm interested in these border cases that we actually already see, if nowhere else, so we see them in the military industry.
Well, that's another wonderful question, and it does. There are people who have written things related to that. I mean, yourself obviously is one that I'm most familiar with, but also in queer theory and feminist theory, because of their focus on otherness and distinctions, especially from a white male archetype. So I think we have a lot of room for discussions about models from those areas that could be useful in the application of law. I'll just say two things really briefly so that we can have an opportunity for audience questions, but related to your question. And that is a thought experiment, which I think gets to the heart at the problem, going back to your first question, in which a human brain, completely comprising naturally occurring brain cells. And then one by one, each of those brain cells is replaced by a synthetic one, to the point where the brain now completely has only synthetic brain cells. And then you reverse the process and you subtract every synthetic brain cell and replace it with the naturally occurring one. At what point did that brain, if at all, cease to become a natural entity if it was a theory of the mind based on whether it's the software or the hardware, that we'd have to kind of come to a conclusion about which one is more important in a theory of the mind. So I think of that because you could get a really odd boundary case in the far future where someone's body is 90% technology, and even their brain is sort of augmented and keeping them alive. And yet, what kinds of rights to bodily integrity might they have and things like that? If, someone chopped off a robotic arm, is that a human arm that they just chopped off and therefore part of their body? So I think that's another interesting way to think about it. I don't have a really great answer other than I think the more that these boundary cases emerge, the more it will push these sorts of conversations to happen. And I hope that they do, because I think we're eventually going to get to the point where someone will have, a purely synthetic brain, and maybe, or maybe they'd have no brain, but their entire, Elon Musk's project about sort of downloading the human mind. I think at some point it's possible that happens, and so someone's going to exist on a hard drive. Does that constitute a person? The other thing I'll mention, which is much more sort of focused on the letter of the law, there are a couple of scholars that I really look to for their insights on this, Wiesa Kirki and Tomasz Piotr Zakowski. And Tomasz has written that instead of trying to say something is a human or not, and we're thinking about law, and especially the thorny issue of personhood, we should apply this other category, which he calls non-personal subjects of law. So you are admitting that it is not a person, but it is still a subject which has some kind of interface with the legal system. And I think that to me is kind of maybe a middle ground approach where we don't admit that an animal is a person, because even though we have natural and artificial persons under the law, for some people they still will not be willing to see that as a full-blown human, if a human is sort of synonymous with a natural person. But maybe a non-personal subject of law gets us away from calling them objects, but more toward in seeing how they could actually be part of a legal system. So that's an interesting idea that I think is worthy of further exploration.
Thank you.
All right, so let's move on to some questions from the audience. There are several really interesting ones. And I'm going to combine two questions actually, because there was one person asked whether the rights that you're talking about were then limited to the human needs, which may change and undermine those rights. So in terms of that relationship, and there was another question that was actually also posed in the last panel to Erin and Jim on thinking about how, in terms of how we are in some regions of the world, how we haven't even achieved the human rights that have been declared for such a long time. How does that relate to all of that you're talking about here?
Two very good questions. The first about human needs, I would say, if there's nothing else that people get from this kind of project, and I'm by no means the only person who's sort of working in this space, it's that the Anthropocene informs us empirically, ethically, that it is no longer tenable to place human needs and interests above those of the whole planet. Because we will produce the very conditions that lead to our own ruin and the ruin of everything else around us. So that requires a kind of shift in thinking in which humans will need to be at least capable of denigrating or maybe demoting their own interests and needs and making them subservient to those of the whole. And so I certainly don't advocate for or make an argument for in my work that there's an important part of this that has to address human needs, because and this is maybe more of the science fiction part, but it could theoretically be the case at some point that artificial intelligence generates needs of its own. The example of this that I just read about yesterday was something about making the whole world like ordered by paper clips, right? Now that's not something that a human would come up with, and maybe that doesn't seem like a very valid or legitimate need, but it will be a need that will be expressed and perhaps pursued. So we have to think about not only ourselves. I think that's just the kind of bare bones, I guess, conclusion that I can reach about this. That law, environmental law in particular, has been so poor at trying to address, because so often it has simply reified the importance of human needs and human interests to the detriment of everything else around it. So that's the first part. And the second part is, let me see if I got this right. There are other non-humans. How do we, sorry, maybe you could just restate it, because I'm sort of drawing a blank right now.
On the second question, you mean?
Yes.
So it's basically how the traditional human rights that have been established for a long time, there are some regions that haven't even achieved those. So
Okay.
why are we talking about rights of non-humans here?
Sure. So the way that I mention or respond to this sort of a critique is often that we can walk and chew gum at the same time. And it is not often the case that we have completely protected one particular right for everyone in humanity, and we're ready to move on to the next one. There are always these projects occurring in tandem. I think the important thing to consider here is that right now we are just at the very beginning of seeing where these rights issues are emerging, whether it's in the context of nature. Certainly we've seen this for a long time in the context of animals, but even more recently in the context of robots. So if we do not have these sorts of conversations, we risk being caught flat-footed when a real legal conflict emerges and we are struggling to identify how to resolve it. So I don't think it's too early to think about that. And I certainly don't think that we should stop working on other very important human rights issues related to human trafficking, migration, environmental injustices. All of those clearly need to continue being addressed, but we also need to have resources, institutions, frameworks that are also galvanized around addressing this burgeoning issue, because it's certainly not going to go away. And the more that we try to push it off to the future, the more unprepared we will be for it when it fully emerges.
Wonderful. So there are other two questions here posed. So one of them is how to solve the issue of legal representation of non-human entities, including nature and robots. And then what about the individual criminal responsibility of crimes against nature, given the recent proposal to include ecocide as in the International Criminal Court statute of Rome. And then there was a follow-up question related to that, which is whether a robot could be criminally liable for ecocide at the ICC.
Sorry about that. That's definitely, I think a really interesting issue, which I'm not sure I have a great response for, but that's part of why we have people asking questions, is to bring these things that we haven't thought about before. But I'll start by talking about legal representation, because we do already have some examples of that. In India, they have representative standing, where someone who can allege that they have a vital stake in nature, for example, could bring an issue on behalf of that There was recently a German case which was rejected by a federal constitutional court, which sought to argue that piglets had standing and that PETA, the animal rights organization, was the appropriate authority to represent them in a court of law. I think we're going to have to do something like a kind of representative standing. And it's not going to be, clean as far as what that looks like. I think it's easier in the environmental context because you could, for example, have an indigenous group that has resided in a particular part of the Amazon for time immemorial. And so they would have a vested interest in trying to represent the interests of nature in a court of law where development threatens its existence or something like that. For a robot, or artificial intelligence, it's a bit more difficult, especially because the chain of causality winds up moving further and further afield as we move from something like, some forms of artificial intelligence to unsupervised machine learning, where we ostensibly had a programmer who set up the form of artificial intelligence, but then the AI just kind of ran off with its own because it trained itself based on data that it acquired from all over the place. So who would be potentially eligible to represent the interests of a robot? The typical examples that are raised in literature are, there's the end user, there's the programmer, there's the company. Outside of that, there may be other stakeholders as well that we haven't thought about. It could be, for example, that a government contracts a company, uses artificial intelligence, and so once you purchase it, you then become responsible for how it acts. Think of something like autonomous vehicles. If the government establishes a contract with an autonomous vehicle company, maybe they have to assume responsibility. And that sort of gets into that third question about ecocide and criminal liability. I think the ecocide development is also a very interesting one that is happening almost in tandem with the rights of nature. But of course, you're not going to probably see people arguing that nature is responsible for committing ecocide. So criminal liability is, its own bag of worms. People like Ryan Abbott have talked about this in the context of artificial intelligence, and so looking at concepts like strict liability. And I think, at least at first, it's going to probably be based off of some existing legal doctrine, and it will simply be attached to that unless things get so much more complicated that it's impossible to really do that. So I think you could have, for example, I think Abbott talks about like an insurance scheme. So if you possess a robot, you've also got to buy insurance. That will in some ways inoculate against these concerns that no one will be held responsible if a robot does something bad. There's also, again, the sort of the transferability of liability from one entity to a next. So there's ways of thinking about that. I have not given really any thought to the whole ecocide question. So I'm going to probably leave that one to people who are more versed on ecocide to think about. But, just as a hypothetical, I think it's interesting to work through what if, some machinery operating under artificial intelligence directs itself to plow through the Amazon. Who's responsible for that? People like Ryan Abbott have already given some thought to it, but I think it requires a conversation involving indigenous groups, involving governments, local governments, and national governments to determine what would be appropriate in terms of criminal law, or at least assigning responsibility, because that is also one of the chief complaints about this idea of robot rights. Is it's simply an effort to pass off responsibility for companies that would produce robots that are capable of doing bad things. So I think ecocide is a fascinating area to try and think about the rights of non-human entities.
Right, wonderful. Thank you so much. I love that you're bringing the Amazon as an example here too. All right, so I think we're gonna close up that on that note, because we have a lot to think about for sure. There's definitely it's a topic that's been developing, so it's interesting to think about these things as we move forward. So I'd like to thank Josh and Matilda again, and thank Dina and Angela for organizing this wonderful summer course. And I'd also like to remind everyone that we have 2 more classes tomorrow, one on children as political actors and the other on business, human rights, and the environment. So we'd like to invite you to join us there as well. And all of those sessions will be recorded too. So you're welcome to watch afterwards as well. So thank you, everyone. And I look forward to seeing everyone soon.
Thank you, everyone. Thanks for coming.
Thank you so much. And thank you for giving me the opportunity to come and discuss as well.
Bye.